Hello. Welcome back to Module 2, Foundation of American Government. Today, we will go over Section 2, Natural Rights. In this video, you will learn about this important concept and how it is the bedrock of nearly everything in the American system of government and civil society. The general rule or first authority cited in the Declaration is the laws of nature and of nature's God. The founders credited nature's God as the one responsible for the natural order and the ultimate source of government power. Natural law is the moral laws perceptible to human reason and obligatory to all human beings regardless of time and place. Cicero said, "True law is right reason, consonant with nature, spread through all people. It is constant and eternal. There will not be one law at Rome and another at Athens, one now and another later, but all nations at all times will be bound by this one eternal and unchangeable law, and the God will be the one common master and general, so to speak, of all people. He is the author, expounder, and mover of this law." This concept was echoed by Enlightenment thinkers like John Locke in his two treatises of government. The state of nature has a law of nature to govern it, which obliges every one, and reason, which is that law, teaches all mankind, who will but consult it, that being all equal and independent, no one ought to harm another in his life, health, liberty, or possessions. Locke is saying that natural law serves as the foundation of natural rights and as the moral limit to liberty. Natural rights are those rights possessed by individuals because they are human beings. The concept of natural rights is that universal moral principles lie beneath human laws. For example, murder, or homicide, can be defined as the deliberate taking of a human life without the justification of war or self-defense. Homicide has been a crime throughout human history in nearly every society that possessed some type of legal code. Even in civilizations that had no contact with each other, murder was known to be wrong, and its prohibition is rooted in a natural right to life. Every person in any place and time has rights and the ability to make a moral claim to natural rights. Again, you have these rights not because a government has given them to you, but because you are a human being. The idea of natural rights is thought to have come to the American colonies in approximately 1710 and was disseminated and discussed for some 50 years. By around 1760, natural rights had become a widely accepted doctrine in North America. Every human being has a natural right to liberty, and the freedom to act without infringing on others' rights. All other rights are derived from this fundamental claim. Once your right to be free is established, that means you have a right to not be assaulted or killed. As already mentioned, you have a right to life and self-preservation. Locke said, "Every one as he is bound to preserve himself, and not to quit his station wilfully, so by the like reason when his own preservation comes not in competition, ought he, as much as he can, to preserve the rest of mankind, and may not unless it be to do justice on an offender, take away, or impair the life, or what tends to the preservation of the life, liberty, health, limb or goods of another." Influenced by Locke, Alexander Hamilton wrote in Federalist No. 28, "If the representatives of the people betray their constituents, there is then no recourse left but in the exertion of that natural right of self-defense which is paramount to all forms of government." You have a right to use your mind and your body to acquire and possess property. Private ownership was considered essential to personal independence and security. Locke said, "Every man has a property in his own person. This no body has any right to but himself. The labor of his body, and the work of his hands, we may say, are properly his. Whatsoever then he removes out of the state that nature hath provided, and left it in, he hath mixed his labor with, and joined to it something that is his own, and thereby makes it his property." This was considered an extremely important point. Adam Smith, writing in The Wealth of Nations, said, "The patrimony of a man lies in the strength and dexterity of his hands, and to hinder him from employing this strength and dexterity in what manner he thinks proper without injury to his neighbor is a plain violation of his most sacred property." Indeed, the concept of free labor was widely shared. John Trenchard and Thomas Gordon, writing under the pseudonym Cato, observed, "By liberty, I understand the power which every man has over his own actions, and his right to enjoy the fruit of his labor, art, and industry, as far as by it he hurts not the society, or any member of it, by taking from any member, or by hindering him from enjoying what he himself enjoys. The fruits of a man's honest industry are the just rewards of it, ascertained to him by natural and eternal equity, as is his title to use them in the manner which he thinks fit, and thus, with the above limitations, every man is sole lord and arbiter of his own private actions and property." According to this idea, you have the right to produce, through your labor, goods and services for either your consumption or to barter and trade with others who will consume those products. Property, production, and consumption serve the end goal of self-preservation. You have a right to be free from arbitrary rule. As we have discussed, the Magna Carta was a major restraint on the concept of absolute monarchy. The English Bill of Rights, established in 1689, sought to curtail the abuses of King James II by limiting royal powers and upholding the rights of Parliament and the individual subject. These are examples of the idea of the rule of law. This means that we are a government of laws, not of people who might rule indiscriminately. No person is supposed to be above the law. The rule of law depends on stable laws that are accessible, possible to comprehend and respect, treat people fairly and equally, and provide advance notice of what is expected. In deciding the case of Dr. Thomas Bonham in 1610, Edmund Coke said that the king must not be under any man, but under God and the law. He further argued that, when an act of Parliament is against common right and reason, or repugnant, or impossible to be performed, the common law will control it, and adjudge such an act to be void. The American founders believed that the English under King George had abandoned their traditions and respect for the rule of law. James Otis, writing in his pamphlet, The Rights of the British Colonies Asserted and Proved, declared, "To say the Parliament is absolute and arbitrary, is a contradiction. The Parliament cannot make 2 and 2 equal 5. Parliaments are in all cases to declare what is good for the whole, but it is not the declaration of Parliament that makes it so. There must be in every instance a higher authority, God. Should an act of Parliament be against any of his natural laws, which are immutably true, their declaration would be contrary to eternal truth, equity and justice, and consequently void." Finally, you have a right to worship or not worship that higher authority according to the dictates of your conscience. Locke opposed the idea that the English king held absolute power by divine right and that English subjects were required by law to submit to the established Church of England. Instead, Locke argued that, when they made the social contract, rational individuals would not surrender any of their religious freedom, for they could reasonably hope to attain eternal happiness or salvation only if they used their minds to seek the truth about God and the path he desired them to follow. Locke viewed religious liberty as an inalienable right, one vital to the notion of self-government. Writing in A Letter Concerning Toleration, Locke argued that the purpose of government was to procure, preserve, and advance civil interests, which he defined as life, liberty, health, and indolency of body, and the possession of outward things, such as money, lands, houses, furniture, and the like. To his reasoning, religious affairs were not the business of government, including the establishment of laws that discriminated on the basis of religious belief or institution. Whereas, the Church is a voluntary society of men, joining themselves together of their own accord, in order to the public worshipping of God, in such a manner as they judge acceptable to him, and effectual to the salvation of their souls. To Locke, people were responsible for their own eternal souls and must individually decide how to secure their own salvation. In short, natural rights emphasize that every individual has intrinsic worth. The phrase, unalienable rights, in the Declaration reflects these Enlightenment ideas. As mentioned at the beginning of this section, the Declaration opens with an appeal to a higher moral authority than the king or Parliament. The Declaration cites God as the first authority. He is described as maker of the laws of nature and of nature's God, as a lawgiver, or, in other words, a legislative branch. As divine providence, he is a protector, or an executive. And, as supreme judge of the world, a judge, or a judiciary. And, as creator, a founder, or a constitution maker. King George tried to combine all of these powers into a single person. On a higher level, he was trying to control all laws of nature himself as the one responsible for the order of all things. However, mere mortals cannot rightfully wield that much power for the common good. Baron Charles Montesquieu wrote, "Nor is there liberty if the power of judging is not separated from legislative power and from executive power. If the power of judging were joined to legislative power, the power over life and liberty of the citizens would be arbitrary, for the judge would be the legislature. If it were joined to the executive power, the judge could have the force of an oppressor. All would be lost if the same body of principal men exercised these three powers. The only entity that can be trusted, according to the founders, to wield these powers is named in the document, only God." Jefferson had earlier written, that these are our grievances which we have thus laid before His Majesty, with that freedom of language and sentiment which becomes a free people claiming their rights, as derived from the laws of nature, and not as the gift of their chief magistrate. Let those flatter who fear, it is not an American art. To give praise which is not due might be well from the venal, but would ill beseem those who are asserting the rights of human nature. They know, and will therefore say, that kings are the servants, not the proprietors of the people. Next time? Now that we have considered the idea of natural rights, we will move on in the next video to the concept of equality that is so important to the American founding. Until then, thank you for your time. If you want to learn more about the subjects we have discussed, here are the sources used for this section.